The third exception is point not pleaded but presented and developed without objection. Section 4 Limitation Act 1953 states that limitation shall not operate as a bar to an action unless it has been expressly pleaded as a defense. Under Order 18 Rule 8 Rules of Court 2012, some matters must be specifically pleaded, for example, performance, release, any relevant statute of limitation, fraud or illegality. This can be seen in the case of Kalamal against Manikam, where the court held that if a defendant wishes to rely on a statute of limitation, this must be pleaded. Reference may also be made to the federal court case of KEP Muhammad Ali against KEP Muhammad Ismail and the Privy Council decision in Overseas Chinese Banking Corporation Limited against Philip V. Ki Puan. In both cases, the claims were statute barred and this was pleaded by the defendants. However, there were also acknowledgements of the debt by the defendants which would have extended the limitation period. Here, the acknowledgements were not pleaded by the plaintiff in their respective statement of claim or reply. In both cases, the failure to plead the acknowledgements were proved not to be fatal. Although it appears quite clear that the failure to plead the acknowledgement is a serious lapse in the strict compliance with the rules of pleadings and the plaintiff should suffer the consequences, nevertheless, the federal court in KEP Muhammad Ali treated this as an exception to the principle that parties and the court are bound by pleadings. The decision in KEP Muhammad Ali was affirmed by the Privy Council in Philip V. Ki Puan's case. In this case, the Privy Council confirmed that the failure on the part of the respondent to raise an objection to the admission in evidence of the respondent's letter, which was an acknowledgement of his own indebtedness to the bank, had the effect of making the letter part of the total material on which the judge had to decide the case. The fact that the acknowledgement was not pleaded was rendered immaterial. In other words, the decision of the Federal Court and Privy Council in KEP Muhammad Ali and Philip V respectively are restricted to the facts and not to be taken as of general application.